and they're having trouble, and you go with them down to the bank and help them out, that's a client for life. So what types of assets go into a trust? Bank accounts, valuable personal property, brokerage accounts, business interests, stocks, bonds, autos, boats, insurance policies, and other personal property. All right, let's talk a little bit. Well, this breaks out into those different. Okay, if not, I'll come back to it and go more individually. These are all things that are kind of tax neutral. So it's not tax qualified. You can put it into your revocable trust and it can see through to you. However, IRAs, 401ks, even Roth IRAs, Roth 401ks, all these other tax deferred or tax free accounts, if you move it into the revocable trust, it's gonna blow up that special tax status. The government is going to treat it as if it were a distribution. So, oh yeah, I've got $1 million in my IRA. Let me move it into my revocable trust. Uncle Sam goes, great, that's $1 million of income in 1 year. Pay us the taxes. Whoa, 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 that's not what you want. So this is where you're using the beneficiary designations as part of the funding process to make sure it goes to the right place. Now I'll go ahead and we may come to another slide, but I say it's three options, three main ones when you're talking about a tax qualified or even a tax-free account. If it's a spouse, okay, usually they're the primary beneficiary unless there's some reason not to. Sometimes they keep this separate. It may go to the kids right away. But if so, usually it's the contingent beneficiary. You've got those three options. If it's an individual, go right to the three options. One, you make the revocable living trust the beneficiary. Okay, it goes into the trust. It has all of the protections, the ages of inheritance. You've got the trustee in charge of it. But usually I slam my fist on the desk just to emphasize the point to my clients. But it's taxed immediately. Well, okay, wait. You get an accountant. They can spread that tax out for the beneficiary over a 5-year period, and it's an even schedule. Okay. That kind of implies there might be a better tax way. Well, yeah. You can name the beneficiary directly, and now they've got a tax option. They can set up an inherited IRA. The money goes into the inherited IRA, and now the beneficiary has 10 years to pull that out. No one's telling you have to take a certain amount any given year, but it's all got to be out by year 10. So the way I explain this is a fairly new rule, at least in terms of legal and estate planning and tax planning. It was kind of designed for people who might make a lot of money on bonuses and commissions in certain years, but other years they might not. Okay, if they have a really good year, lots of commissions and bonuses, they may not want to take out too much because it's pushing them into the upper tax brackets. Okay, something happens in their industry the next year, they really don't make as much. Okay, there's now more room to pull money out and still stay in the lower tax brackets. They take more out. The one thing you don't ever want to do is just let it all sit there and end up with a tax bomb at the end of year 10. But this is all up to the beneficiary.
If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel.
There are no age limits. There's no trustee involvement. It goes to them directly. All right, well then what's that third option? I want the protections and I want the 10 years. Well, okay, now you're talking about setting up IRA trusts. So it's got all of the very specific tax language that allows the trustee to set up the inherited IRA. It allows the trustee to handle the distributions coming out of the account. But just because it comes out of the account doesn't mean the money has to actually go to the beneficiary. it's got to be taxed. Now, this can be done on a trust tax return, or check with your accountant, because this is kind of what I've been told, and I've been taking it that, yes, they're right. You can just do a K-1 or a 1099 or whatever the form is to put that tax on the individual's tax return, which is typically at the lower rates. You don't have to actually give them the money, but okay, if it makes their taxes go up by $2,500, write a check for $2,500 to the IRS and to the state taxing agency to handle that difference. This requires some cooperation with the beneficiary. And look, if they're not going to cooperate, okay, it's going to have to be on a 1041 and it's going to be at higher tax rates. So those are the three options for naming beneficiaries on those retirement accounts. Well, what about Roths? Because I get this question a lot. Well, with Roths, you still have those options. It just changes the tax landscape. All right, the Roth IRA paying into the revocable trust, it still has to come out. It's not taxed, so it's tax-free, but there's no more tax-free growth. If it goes to the beneficiary and it's even inside, or even if it's inside an IRA trust, it's tax-free money. It can still continue to grow tax-free, but it's all got to come out by the end of year 10. So you look at each of those a little bit differently, but it's still the same options. Right? So now with the revocable trust, it's only lump sum or 5-year payout option. All right, so trust assets versus qualified assets. If you can put it in the trust and it's not going to have a tax impact, do that. All right, so bank, credit union accounts, checking, savings, CDs, safe deposit box. Now, this is something that I've come across. Banks will typically tell you, oh, well, we can't move your account into the trust, but what we can do is we can set up a new account in the name of the trust and move the money over. Okay, that's fine, except it's going to you're going to have to reset any of that automatic money coming in and automatic money going out. Now, the reality is for a lot of my clients, they have the quote household operating account. And if it's a husband and wife, it's their joint account. But they don't keep like a lot of money in there because it's designed for the money that comes in is what they're spending each month. And if they need to move money out for investments, they can move that out into accounts that are in the name of the trust. All right, they're going to have to weigh what's more of a pain for them. Redoing all that automatic money going in and automatic money going out, or hey, it's not a big deal. They can go ahead and redo that and have just that account in the name of the trust. But with that option, I don't let my clients get away with, oh, well, I'll just make everything pay on death to the trust because it's easier. And banks in particular will go, oh, well, we can just do that. Well, wait a minute. I've had significant enough problems with a power of attorney being accepted when somebody becomes incapacitated to say, no. If you can get it into the trust, do that. So if you're just leaving out that one account, because it's the operating account, it's got all your automatic deposits and bill pay coming out, okay, counsel your clients on what that means, but everything else, try to get it into the trust. CDs, another thing that I sometimes hear, oh, well, if we move the CD, it's as if you're withdrawing it, you're going to lose all of your interest. Well, okay, if you got 3 months left, as long as you don't have some potential impending death, okay, wait the 3 months, and then when you're rolling over the CD, roll it over into the name of the trust and restart whatever that interest is. And safety deposit boxes, you got to check with your specific bank rules because they will put a safety deposit box in the name of the trust, but it's generally a good practice, as long as you trust your trustees, just list all of them as active trustees, even though they really aren't, so that at any point, if you do pass on, they can get into the safe deposit box, wherever they are in that list. Vehicles, cars, boats, airplanes, get those transferred into the name of the trust. Now, I think there might even be something in the materials that talks about airplanes. I actually had to go and do that for a client once, and it wasn't terribly complicated. But yeah, get those into the name of the trust. Real estate. This is something where you definitely want the attorney to handle this, because a deed is a legal document. And it's also something that's really easy for somebody to mess up if they're going to try to do it themselves. Oh, I'll draft my own deed, no problem. Oh yeah, there's going to be a problem. There's quitclaim deeds, which is basically saying, okay, hey, not doing any checks, not looking at any title, anything, any interest that I have in this real estate, I am moving it into the trust. Look, that's the way I do it, but my clients understand and know that. I've heard other attorneys say, no, you really should do a warranty deed, but okay, a warranty deed means you've done all the checks and looked at the title and there's no claims or any of that other stuff. My office just isn't set up to do that. If a client insists on warranty deeds, we're gonna kick it over to a real estate attorney to help with that. Just this morning, I saw a video. There was a gentleman whose house was probably worth about $760,000, but they found out that the county had an easement that ran right through the middle of his house for water pipes. And it wasn't, it didn't end up on the actual easement paperwork. It didn't get filed until many years after the easement was claimed and granted by the county. And a real estate developer had already sectioned everything off and put it into lots and sold those lots. And so here they were 90 years later, and their house is basically worthless because there's this easement with water pipes running under everything. And the title insurance company is trying to get out of it, but hey, we didn't know because the county never posted the easement. But look, that's what title insurance is for. That really should be taking care of it. It's going to be interesting to see where that goes. All right, so these are just examples of the deeds. There's the quitclaim deed. Let's see. Just again, lists of information. Here's a copy, an example, special warranty deed. And again, items and information. Okay, homestead exemptions. Well, actually, record the deed or not. Look, I'm going to leave this up to the attorneys in their various states, but in North Carolina, we are going to file it because there's kind of like a time limit. If it's not filed, I think within 2 years in North Carolina, it's just ineffective. So no, we file it. Loan acceleration. I hear this all the time. Oh, well, I need to, quote, move my mortgage into my trust. No. That's a debt. Don't worry about debts. The companies will find a way to get their money. You don't have to move your mortgage into the trust. And there's actually federal law that if you, let's say it's a husband and wife, they have the property, they're moving it into their trust, but there's a mortgage, and they're both equally on the mortgage, well, they're both equally on the trust. Federal law, the Gar-St. Germain Act says the company cannot say, this is a transfer that accelerates the due on sale clause and all your money we need to get our money back. So that federal law protects moving that property into the revocable trust. But it has to be kind of in the same proportion, but I think there's also an exception if it's like just the husband or the wife or the partner. They're married, and one of them owns it and they move it into a joint trust. Because they're spouses, it's still going to be okay. It's not going to accelerate that due on sale clause. Now, homestead exemption. Bobby, you have in here, be sure to refile when recording the deed.
That's in a lot of states.
That's in a lot of states.
Yeah.
Yeah, now, North Carolina doesn't have that, but we do now have a requirement on the actual deed to state whether any property that's being transferred is the primary residence. And that's kind of our claiming that homestead exemption is done on the actual deed itself. And that's the way the legislature in North Carolina decided to handle
A
that.
lot of states, though, you do have to actually refile the form and refile it.
Yeah, so you do, in a lot of states, check with the attorney, you do have to refile whatever homestead exemption or paperwork that needs to be done. Closely held companies and partnerships. So, look, if you've got a brokerage account and you've got stocks for all these various companies and you're moving it into the trust, okay. But if you also have a small business, it's the same thing. So if you've got stock in a company, membership interest in an LLC or a partnership, a limited partnership or whatever, move that money, move the interest over into the trust. I think, Bobby, you talked about it yesterday, that sometimes it's like, oh, well, no, it's its own contract, it's its own entity. Well, look, if you die owning IBM stock, that's going to go into probate. It doesn't matter. You have to treat your small business interest the same way. Be sure to document this in the minutes. Now, North Carolina is real easy. It's just kind of a one-page form for an LLC. We can move those membership interests, provided the operating agreement allows it. We're at about 50-50 whether or not the forms that most attorneys use for businesses will have that in the operating agreement. So I do have a quick amendment that can be executed by the members of the LLC. Now, one other thing that I'm going to throw in here, I don't think I saw it when I was reviewing the slides. There are some specific types of companies that you can't move in. And that's for some of these more highly regulated professions. So in North Carolina, there's professional medical practices, law firms, accounting firms. We don't fall directly under the jurisdiction of the Secretary of State's office. We fall under our licensing board, and they're allowed to set, here's the different types of corporate entities and how things can be transferred. I own my office space. That's in a separate LLC. There's no problem with me moving that into my trust, but I can't move my PLLC, my professional limited liability company for my law practice. I cannot move that into my trust. So beware of whatever those rules are. So here's just a transfer certificate, list of instructions on transferring. And okay, application for residence homestead exemption. I guess this is depending on what state it's in.
Right.
They may have an actual application. Like I said, North Carolina, you just claim it on your deed. It depends on state law. So beneficiary designations. For non-qualified accounts, look, if you can move it into the trust, move it into the trust. I hate to say this, but the larger the institution, the more problems I've seen that if you're just making an account pay on death into the trust, if somebody becomes incapacitated, they're not accepting the power of attorney. They're telling you, oh, well, now we need you to go to court and get a conservatorship. Well, that's living probate. That you want to be able to avoid that. If you've got a non-qualified account, put it into the trust. Qualified accounts we talked about. So you've got those different options. All right, so.
Another thing is insurance. Insurance is not required. Oh, sorry.
Okay, yeah, insurance.
Insurance is not required to go into a trust. It has a designated beneficiary, but if you want to control distribution, it might be an advantage.
Okay, yeah, let me talk a little bit about life insurance. I'm sorry, I didn't see a specific slide on that.
There wasn't, that's why I thought I'd bring it
Okay.
up and go into.
making life insurance the pay on death beneficiary that's usually good enough if it's just a term policy. Okay, if it's just a term policy, I haven't seen too many problems with, oh, well, it's going to a trust, so we need this information, or we need you to go to court, we need to get, letters testamentary from the trust. I haven't seen any of those problems. The problem would come about if you do have something like a whole life where you've got a cash value and you need your trustee or your power of attorney to have control over that if you become incapacitated. That's when you might want to consider moving the ownership of that policy into the trust, as well as making the trust the pay on death beneficiary. Remember, that cash value is an asset that might need to be accessed if you become incapacitated. A couple of other things before we open it up for more questions, because I get these a lot. Health savings accounts. All right. You kind of treat it as if it were tax qualified money. So, but the only person who can continue to defer that money would be a spouse. So you can't name like your kids or your child to inherit your health savings account, and they cannot have to pay the taxes. They can just keep using it as a health savings account. A spouse can. So that's one thing that's a little bit different that I've seen.
There's a couple other little things people don't think about. Burial plots.
Burial plots. Okay, yeah, you mentioned burial plots going over into the trust. This is also kind of theoretically along the same lines as that I've seen as timeshares. Okay, if you get a timeshare that has a deed, all right, you've got to move that deed over into the trust. But a lot of timeshare companies, they were using these deeds as a gimmick. It's like, oh, look, you're actually investing in real estate. You're getting 1/52nd or 1/26th of this actual townhouse, and here you get a deed. Well, then, as the years go on, everybody's moving it into the revocable living trust. They're passing on, and it's real estate, and the companies go, oh my gosh, this thing that we were using as a gimmick is suddenly becoming this big legal thing. And so the newer timeshare companies started saying, no, look, we're going to do contracts and points, even though technically you're kind of tied here. It's actually the same way with a lot of burial plots. You're getting your burial plot, but it's kind of organized around the cemetery and their business organization that has the plots. So you may not actually be moving it into the trust with some kind of deed. It's making sure that it's reflected in that cemetery organization that here's how the plots are going to be controlled. And it can be controlled by the trust and the trustee at the time.
You have a question.
We've got questions. Okay.
So Heidi says, I thought children, even adult children, had 1 year to use the HSA for qualified expenses, then had to take any future years more like a taxed IRA.
Okay, that's something I'm not familiar with. And you may very well be right, Heidi.
I would have to ask an attorney on that myself.
Yeah.
Also, on timeshares, I don't put those in the trust. The only way to get out of timeshare is to die or pay a small fortune to an attorney. Timeshare companies are happy to transfer the deed to children if they actually want them.
Okay, and that's a very good point, because I should have said it. If you want to pass along the timeshare, then you should move it into the trust. There are a lot of these timeshares that they did look at it as a real estate investment. They signed up for the paperwork. They watched the value go up. They used it as a vacation property, or they got the money for leasing out their time. But now these are 30, 40-year-old townhouses with a lot of work that's needed, and they have to pay their proportional share of those upkeep costs and they may not be using them anymore. So a lot of my clients want to get rid of them. And at that point, I'm telling them, yeah, don't move it into the trust. Just let the contract die. Because a lot of these timeshares, even if you're trying to sell them for $1, provided they sign off that they're taking up those maintenance fees, they can't get rid of them. And so, like Heidi said, yeah, it could be a small fortune to get. Usually it's a law firm. I just kind of been briefed on this from one of my clients. To get a law firm to actually sell to break the contract. Well, okay, if you die and it hasn't gone anywhere, you just kind of abandon it and let the company take it back. That might be the most efficient way to do it. Yes?
On the life insurance part, I understand the whole life in it, part of the trust. But I don't understand why we wouldn't put the term policy in, because it's gonna then be part of the estate, the value in the end.
Well,
Right?
no, you're naming the trust as the pay on death beneficiary, but you're not moving the ownership of the term policy necessarily over into the trust. Because there really isn't any value until you pass on. And like I said, just as a practical matter, I haven't seen too many issues with the life insurance companies just writing the check out to the trust, because the trust is the beneficiary. Okay, you got us the death certificate, you filled out this form, here's the check. Done. The other thing, and I mean, this just popped up yesterday as a question from a client, because they never went through and actually funded their trust. They just sold their house, which we moved into the trust. The bank won't put this into my personal account, and they didn't have any accounts in the name of the trust. The check was written out to the trust because that's who owned the property, and they had to sign everything in the sale as the trustee. Hey, I've got this check. Well, okay, you didn't fund your trust, you didn't move your accounts into the trust, so what do they do in that case? Open an account in the name of the trust. Actually do the trust funding stuff we've been telling you to do for years. But with that life insurance, there's no need for the trust to own it because there's no actual value until it pays out at death.
Now, when we get to the advanced section, there is reasons, and we'll kind of go over that later on today.
But you're not talking about a revocable
We're not
trust.
talking
You're talking
revocable.
about an irrevocable trust.
Yes.
And this could be a big thing, especially with the taxes coming down. So just
Yeah,
a little bit of
we'll
a
get there this afternoon.
teaser there. All right. Any other questions?